Well, this inquiry, which we've just completed, is a rather unusual one because it is about a choice which the British government has to make by the 31st of May 2014 at the latest, on whether or not it is going to opt out of 130 bits of European Union legislation on justice and home affairs, which were enacted by unanimity, that's to say with Britain's agreement, before the Lisbon Treaty entered into force. That's a choice for the British government to make, but we've conducted this inquiry in order to provide a proper background and factual, evidence-based material for the debates which will take place in both houses, and our report, of course, is directed to the House of Lords. Well, the government has 2 months to reply to it. That's the normal practice with European Union reports, and so presumably they will reply at latest by the 23rd of June, which is 2 months from the day of the report's publication. That will not necessarily be the end of the story. It would be the end of the story if the government decides not to go ahead with the opt-out, because there is no need for a further parliamentary procedure in that event. But if they were to decide to go ahead with the opt-out, then they have committed themselves to debates in both houses followed by votes. And so I can't tell you what the timing of that will be. It will be in the hands of the government. But it necessarily has to be before the end of May next year.
In the preparation of this report, during the course of the inquiry, we made every effort to take views from all shades of opinion. Those who initially favour the government exercising the opt-out, and those who are against. And it has to be said that those that are against include most of the professionals involved in fighting crime and legal professionals. Now, we also came to the conclusion that in the light of the evidence, the preponderant amount of the evidence that we received, that the government had not made a convincing case for exercising the opt-out. We concluded that it really is in the United Kingdom's national interest to remain fully involved in the vast majority of the 130 measures which are subject to the opt-out. We think it's in the interests of national security, the fight against organised crime, the fight against terrorism, that we are fully involved with organisations such as Europol and Eurojust. We are, of course, we also look very carefully at the European arrest warrant, which is perhaps the most high-profile measure, which is the subject of the opt-out. And we came to the conclusion that although there are certain shortcomings, on balance, the benefits are such that we should remain parties to that agreement, and that in the event of the opt-out being exercised, there shouldn't be any gap between opting out and our application and the effective opting back in. The other measures under other conventions which could be used to replace the arrest warrant really would just lead to delay and probably more injustices than the arrest warrant may have caused in certain cases. We also need to remember that a number of the 130 matters that are the subject of the opt-out involve the protection of fundamental rights of British citizens who may be travelling in other European countries or working in other European countries. And so this oughtn't to be lost sight of. We haven't been able to give in the report a definitive list of the items that the United Kingdom government should seek to rejoin, because we haven't had from the government either their promised memorandum, explanatory memorandum on the various issues. We've had no indication from them of the issues that they would seek to opt back into. And in negotiations with the Commission and with other member states, it's going to be vital that that information is available. And so in our report, we've made it quite clear that when the House comes to consider this matter, the government really should make available to the House the measures that they want to opt out of, the measures they want to opt back into, the measures which they consider to be defunct, where they believe they stand with other member states regarding negotiating or opting back in. Without that kind of information, Parliament cannot take a fully informed decision on any motion which the government puts to the House.